Major breaking news. The United States Court of Appeals for the Fifth Circuit has just decided the George Peterson suppressor case under the NFA yet again for the third time. And yes, indeed, for the third time, the Fifth Circuit three-judge panel has screwed this up. Please, oh please, someone at the Trump Department of Justice and or in the Fifth Circuit, stop this madness. The number of mistakes and insanity going on with this case is just too much. And we're going to break all this down when we come right back. A lot of unnecessary errors in my view here. Let's break it down right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. And you know what I'm going to say? I've been renominated for the 2026 Gundies Awards for the top voice in the Second Amendment, the top voices of the 2A. If you're so willing, please go over to thegundies.com and vote for the Four Boxes Diner and the top voices of the 2A for the 2026 Gundies Awards to be awarded at the end of January in Las Vegas. I appreciate your support. It is a great honor just to be nominated, but let's see if we can do the repeat. I know it's hard, but let's give it a try. All right, folks. Oh, my God. Okay. So we have the third opinion by the three-judge panel written by, yet again, Judge Jennifer Elrod, who's a very nice lady and a very smart judge, but I gotta say, this is a mess. It continues to be a mess, and somebody's got to step in and stop the madness. We'll talk about that in a moment. But we have another, for the third time, we have a three-judge panel in this criminal case of United States versus George Peterson. This is a case you may recall where George Peterson was arrested by having a unregistered homemade suppressor in his closet. He pled guilty to violating the NFA because of this thing in his closet. By the way, this was a raid that was conducted in 2022 in the Biden administration years. So they were going after these malum prohibitum crimes. As you know, malum and se crimes are things like murder, rape, and robbery. They're evil in and of themselves. Malum prohibitum crimes are the crimes that are just crimes because the legislature says so. Things like, I don't know, jaywalking, for example, or having a gun barrel that's too short or too long or whatever it is. There's nothing moral or inherently evil one way or the other about this stuff. And that also applies to having an unregistered suppressor. Obviously, nothing morally repugnant about that in any respect. It just is illegal because the federal government says so. All right, so with that said, he was arrested, he pled guilty, but he preserved his right to challenge the NFA as applied to him on Second Amendment grounds, which is what he did all the way up to the U.S. Court of Appeals for the Fifth Circuit. You may recall this. There was no fewer than 3 decisions written by this three-judge panel by the majority author of these opinions, Judge Jennifer Elrod. You may recall that they issued opinion. Then they said that suppressors were not arms in the first under the text of the Second Amendment. Then the DOJ under Trump came in and says, well, suppressors are protected under our protected arms, or at least they're arms under the plain text of the Second Amendment. That required the court to reissue another opinion. Then they withdrew the opinion. Now they've issued another one. So it's really crazy down there. There was also a request for an en banc review for the entire Fifth Circuit, all the judges in the Fifth Circuit, to rehear this case en banc. That was denied as well as part of this George Peterson case involving an unregistered illegal suppressor under the NFA. Okay, with that backdrop, let's talk about what happened here. So this decision today by the three-judge panel down there in the Fifth Circuit covering Louisiana, Mississippi, and Texas is a mess and is clearly wrong. And I suspect they might even think it's wrong and understand it's wrong. And I suspect the DOJ probably thinks that they're probably on thin ice as well because they're all clearly correct. Now, what they're trying to do here, I just want to be clear what they're doing here. I suspect what might be going on here is that they're trying to kind of save face here because what they repeatedly say in this opinion, and we'll break it down, the opinion, in just a moment. But what's very interesting about this is they make it crystal clear that this is an as-applied challenge to the NFA as applied to the specific circumstances of George Peterson. They're not saying that this is a facial challenge to the suppressor rules under the NFA. They're saying this is as applied to George Peterson himself. I don't understand in this particular context how this possibly helps the logic and the accuracy of this opinion by the Fifth Circuit beyond one thing this court kept saying in this opinion is they're basically saying that, oh, by the way, we think that the registration scheme of the NFA is analogous to a shall issue licensing regime signed off by Bruin. Clearly false. We'll get to that in a moment. But they're saying that we think those are the equivalent, and we, the Fifth Circuit panel, thinks that basically the lawyer at oral argument in this case somehow conceded that point, and as a consequence, we're going to go with it as applied to Mr. Peterson. But we, the Fifth Circuit, this is what I'm reading between the lines, we, the Fifth Circuit, reserve the right to reach a different outcome, finding that the NFA requirements involving suppressors are unconstitutional under the Second Amendment in a future case. That seems to be what I'm reading between the lines. For some reason, they didn't want to rule properly for George Peterson, but maybe they're thinking down the road they will do it differently. Makes no sense to me, but I'm just telling you my sense of what's going on here, having read the opinion. Now, with that said, let's talk about the errors made. Oh boy. All right, so the whole opinion starts off on 3 wrong feet, if you will. On page 2, it starts off with the following. Assuming without deciding that the Second Amendment protects suppressors, we affirm the district court's denial of Mr. Peterson's motion to dismiss because we agree with the government that the NFA's shall issue licensing regime is presumptively constitutional under Bruin, and Peterson's as applied, hear what I just said, folks? Peterson's as applied challenge fails on this record. All right, so I'm going to go in reverse order. Notice how they say Peterson's as applied challenge on this record. So again, this is telling me that they know they may have messed this case up and they don't want to be bound by this erroneous decision forever. So they're trying to draw a distinction by this particular case and future cases involving suppressor challenges under the NFA. Doesn't make logical sense in my opinion, but I think that's what they're trying to do, is trying to save face, because again, it's pretty embarrassing if you have to issue 3 opinions in a case and you still can't get it right. That's just my view. You can disagree with me in the comments below. So that's the first thing that's quite telling. The second thing is, they say, assuming without deciding that the Second Amendment protects suppressors. Now, first of all, it is undeniably the case that suppressors are protected arms under the Second Amendment for many reasons, one of which is under Bruin. It says that any instrument that facilitates armed self-defense is an arm. A suppressor is an instrument that facilitates armed self-defense, therefore a suppressor is an arm. Number 2, the Rahimi case specifically says that the plain text level, any government regulation that regulates arms-bearing conduct, not my language, the Supreme Court's language. If it implicates arms-bearing conduct, that implicates the text of the Second Amendment. The burden shifts to the government to justify the modern-day gun control law. Obviously, putting a suppressor, owning a suppressor, using a suppressor on a firearm is arms-bearing conduct. Again, the plain text is implicated, and thus suppressors are effectively arms for the purposes of this argument. And last but not least, as we've talked about before, if you ban suppressors, you're banning an entire category. If you regulate suppressors, you're regulating an entire category of firearms, i.e. firearms that are capable of firing suppressed rounds. So yes, there's no doubt in my view that suppressors are arms under the plain text of the Second Amendment, i.e. the right of the people to keep and bear arms shall not be infringed. But with that said, think about what they just did here. If you assume correctly so that suppressors are arms under the plain text of the Second Amendment, the burden shifts to the government to justify the modern-day gun control regulation, right? So right here under the NFA, what are the 2 components of the modern-day gun control regulation that apply to suppressors under the NFA? One is a registration requirement. The second one is, at least back in 2022, was the $200 tax. Well, think about this for a moment. If suppressors are protected arms under the plain text of the Second Amendment, is there a historical tradition of taxing firearm sales? Absolutely not. We know under the Supreme Court precedents of Harper versus Board of Elections from the 1960s that said $1.50 poll tax was unconstitutional. We know from the 1980s decision in Minneapolis Star that a tax on ink is unconstitutional. These are targeted attacks on constitutional rights. If you have a targeted $200 tax on the possession or use of a suppressor, which is an arm under the plain text of the Second Amendment, you have no historical tradition. That law fails. So the $200 tax under the NFA violates Second Amendment just as a matter of historical tradition. So clearly that is the right answer, and the Fifth Circuit doesn't even address what I just said. They blew it off. Maybe they didn't even think about it. Probably they didn't. She should have, but they didn't. The second thing is registration. Okay, how hard is this? This is the big fundamental flaw of this opinion. It's absurd. They're arguing that because Bruin's footnote signed off implicitly on what are known as shall issue license regimes, a licensing regime says that I have a right to carry guns in public for self-defense, and I get a license for that. And they basically said in Bruin that we're going to basically assume for the sake of argument that those are constitutional. We're not going to say that they're unconstitutional if it's a shall issue licensing regime. This court is trying to draw an analogy to say that a shall issue licensing regime that allows me to carry guns in public is analogous to a firearm registration scheme. This is absurd and completely wrong historically, logically, in every single possible way. A shall issue licensing regime is simply a license that allows you to carry a gun in public, period. It has no connection to a particular gun, a serial number. It doesn't describe how many guns you own or any of the like. A registration scheme says that these guns are owned by Mark, and I'm going to have a centralized list of the guns owned by Mark, owned by the government. Held by the government, described to the government. The government knows the guns I own by serial number and knows that I have them. That is registration. That has nothing to do with shall issue licensing. But don't trust me on this. Why don't we trust another source? Who could that be? Oh, I don't know. How about Supreme Court Justice Brett Kavanaugh, who literally drew this distinction in the Heller 2 decision when he dissented back in 2011. Here's what Justice Brett Kavanaugh had to say, dissenting in Heller 2. Might be helpful to the Fifth Circuit to have read this. Check out what Justice Kavanaugh had to say then about the difference between licensing regimes and registration regimes and how they're totally different. The fundamental problem with DC's gun registration law is that registration of lawfully possessed guns is not long-standing. Registration of all guns lawfully possessed by citizens in the relevant jurisdiction has not been traditionally required in the United States. In considering DC's registration requirement, it's initially important, listen carefully folks, it is initially important to distinguish registration laws from licensing laws. Did you hear that? Justice Brett Kavanaugh literally writes, it's important to distinguish registration laws from licensing laws. Licensing requirements mandate that gun owners meet certain standards or pass certain tests before owning guns or using them in particular ways. Those laws can advance gun safety by ensuring that owners understand how to handle guns safely, etc. Okay, then it goes on to say, registration requirements by contrast. Registration requirements by contrast require registration of individual guns and do not meaningfully serve the purpose of ensuring that owners know how to operate guns safely in the way certain licensing requirements can. For this reason, registration requirements are often seen as half-a-loaf measures aimed at deterring gun ownership. And then Justice Brett Kavanaugh went on to write, after Heller, some licensing requirements remain permissible, and some record-keeping requirements on gun sellers remain permissible. But DC's registration law violates the Second Amendment as construed by the Supreme Court. All right, so there you have it. So to the extent suppressors are assumed to be arms under the plain text, which they are, but the Fifth Circuit assumes it, they needed to analyze whether or not the regulations apply to protected arms under taxes and with respect to registration. Is this meet the historical regulation test, the historical tradition test? The answer is obviously no. But did the Fifth Circuit even try to do this? No, they didn't. They literally, sloppily, intellectually, frankly, lazily decided to compare shall issue licensing regimes with registration regimes, even though this is comparing apples to oranges. Don't believe me. Believe U.S. Supreme Court Justice Brett Kavanaugh. Kind of persuasive authority, I would have thought. Maybe not in the Fifth Circuit, but I would say yes. That's just my thought. And by the way, there's no debate that the Fifth Circuit understands that the NFA is a gun registry. They literally call it a central registry of firearms. Here's what they write in this opinion. Clearly different than a licensing regime. Here's what they write. At the federal level, the ATF regulates suppressors through the enforcement of the NFA. The NFA instructs the Attorney General, listen carefully, folks. The NFA instructs the Attorney General to maintain a central registry of all firearms in the United States which are not in the possession of or in the control of the United States. That is a registration. And if suppressors are protected arms under the Second Amendment, which was assumed here and is the correct answer, you can't have a registration. Justice Kavanaugh understands this. We all understand this. And a footnote consisting of dicta in Bruin dealing with shall issue licensing regimes in the carry context has nothing to do with a central registry of firearms. It tells you nothing about a historical tradition of registration or taxes for that matter, and yet the Fifth Circuit just kind of conflated all this stuff, which again, no can do, simply sloppy in my view, not right. So what exactly is the Fifth Circuit trying to do here? But I think it's kind of telling what they write on page 11 here, because they're trying to say that in their view, the lawyer for George Peterson made some concessions. This doesn't make any sense, and we'll get to that in a second. So here's what they write in this page 11 on their opinion. Turning to this case, we assume without deciding that suppressors constitute arms under the Second Amendment, as both parties now contend. Even so, the NFA suppressor licensing scheme is presumptively constitutional because it is a shall issue regime, as Peterson's counsel conceded at oral argument. Okay, I have no idea whether or not Peterson's counsel conceded anything at oral argument, but let us assume hypothetically that happened. Let us assume hypothetically that Peterson's lawyer literally said, and I have no reason to think this happened, but let's assume he did. Let's assume he said, hey, the First Amendment to the Constitution doesn't protect free speech. So what? You can't concede something that is clearly legally wrong, right? What you can concede at oral argument as an attorney might be something like, we are waiving an argument, or, we concede that my client knew about some fact at the time of the alleged crime. You can concede things about, let's say, the record or what you're arguing, but you can't concede something that is legally wrong. Like, for example, I can't stand at the podium and say, I concede, Your Honors, that the First Amendment right to free speech does not protect political speech. That's just legally false, right? I can't concede something that is obviously wrong. And so too, even though this court is trying to say, well, the lawyer conceded that the shall issue licensing regime is analogous to the registration regime, even if that occurred, which I don't know if it did, even if it occurred, it's not required. The court doesn't have to buy into that, right? It's not a basis for getting a law wrong. Again, this is not about the factual record. This is literally about what is the law. And if I say, no, I don't think that law exists, and the law does, the court can't say, well, the law, he admitted the law doesn't exist even though it does, so I'm going to assume it doesn't exist. That's absurd. That's not how you judge. Again, this is a question of law. What is the law? What does the Constitution require? And I don't see how any party can concede the legal meaning of anything involving the Second Amendment. And that is what they're trying to implicate, or what they're suggesting here on page 11. And I don't think it flies, and I don't think it's a good enough excuse for the Fifth Circuit to simply screw up the Second Amendment jurisprudence here. All right, so there's other points I can make about this opinion, but I don't think it makes sense to spend more time on this. But I will say this. If I were advising the Department of Justice, I would look for a way to get rid of this case. This case is messed up. The arguments here are messed up by the Fifth Circuit. The fact they issued 3 opinions and still can't get it right says something is messed up here. You got to just get out of the litigation position. And remember, this is a malum prohibitum crime enforced by Joe Biden's Department of Justice in 2022. So it's not even technically a Trump prosecution. So if it were me, I try to get rid of this case. I would try to eliminate this litigation because, again, the Fifth Circuit is doing no favors to the Second Amendment. They're doing no favors to jurisprudence, and they're doing no favors to justice, in my opinion. But again, I don't run the Department of Justice. I don't run the Fifth Circuit, so that's just my opinion. And I'll put a link to the opinion of the Fifth Circuit, and you can tell me if you disagree with what I had to say in this video, if I missed something. Okay, there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me there on X at 4boxes. Don't forget to subscribe both to YouTube and to Rumble, and I'll talk to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.